of you online, and we're going to continue working as we did on Saturday, and we're going to have another class on Saturday, and that's where we wrap up the whole international and European gender law or a course, mandatory course, and everything else regarding the finalization of the course, I will tell you on Saturday. Today we will try to cover the most detailed, but also the most important part of the EU law that covers gender equality and gender law in general, and that those are the secondary legislation and directives. So I'm going to do as I did in the previous class. I'm going to start with some short questions that I draw up, and then we're going to do like a little test together. And then with the questions of the test, we're going to try to do no, not test like test for a grade, but test together. Like I'm going to do as a previous lesson. I will in previous class. I'm going to do a quiz, not a test. Boże, it's not a test. It's a quiz. It's a pop-up quiz, which I'm going to share now. And if you want to tell the answer or you know the answer, you can just, some of the answers you definitely don't know. I just put it as the announcement where we're going to work today. And what else? Regarding today's lesson is going to be 8:25, I think. Yeah, I think that's like per schedule, but we're going to have a short break in an hour. So, and I'm going to try to shorten the break on 10 minutes, and then we're going to try to finish a little bit earlier, like 8:15, in order for you to have a peaceful evening, not to think about the gender and law. Okay, so we're gonna share the document. Just a second, if I have it right now. I Bože se otvori. Bože. Yes. Jel vidite? Opet teško, ja. Do you see the questions here? People online see the better resolution than you do, definitely. Jel da? Okay, we're going to start with the very simple ones, which we covered in the previous class, and that is what is the main purpose of secondary EU legislation. But before that, we're going to again mention what is secondary EU legislation in the presentation. But now, just tell me, what do you think that it is the main purpose of the secondary, meaning not the treaties, not the charter that we covered, as we talked about that. That is like the primary legislation, meaning the highest legislation act that exists in the EU, but the secondary EU legislation. There could be multiple answers to each of these, but you can tell me what you think. It's B. Okay. Does anybody else has anything else to add? No, it's B, definitely, because B is to translate treaty goals, because this is what we explained in the previous class, that what we have stated in the treaties, meaning Treaty of the European Union and Treaty on the Functioning of the European Union, is then further developed into the EU secondary legislation and then implemented by member states. And this is how it goes. It goes from the treaties to the secondary legislation to the member states. That is the legislative train. It's called like a train, it goes like that. Which of the following is true about the EU directives? This is where we learn how the EU directives, what are their goals and effects. So could you tell me what of these four is true? Yes. What would be A? Which piece of legislation, secondary legislation, is A? Right. Ne, možete, pa ja volim kad mi se ljudi javljaju. Najgore kad niko ništa ne. Regulation. So A is regulation, B is directive. This is easy. Let's go now furthermore. Probably Professor Ivana Krstić talked about direct and indirect discrimination. We're going to go over again just like a brief explanation of what direct and what indirect discrimination means, but when does it occur? Žao mi je, znači sad moramo se pogledati. Do you want me to read it? Znači, ovdje je baš za direktno, znači where a man or a woman are treated the same.
It's obviously C.
One person is treated less favorably because of sex compared to another in a comparable situation.
Yes, that's direct discrimination.
Yeah, and what would be indirect discrimination?
Indirect would be when one person is treated unfavorably, but not directly. For example, a woman is denied promotion, or an employer does not wish to hire her for fear she can get pregnant and maybe take time off that a man wouldn't in that situation. That might be indirect.
Yes, indirect would be where you have a seamlessly neutral provision, which indirectly affects only one, I would say, sex, or in this case, gender. So, or maybe discriminates other, like based on religion or based on other bases, which we have in a non-discrimination directive. So it's seemingly neutral, and that would be like it produces unequal effects, which is B. Okay. This, do you maybe know which one first established EU equal pay for equal work? C, it is C, yes, because it's the first one, and you learned already that, because in the last class, I think I repeated like 10 or 12 times. That's the first principle where first occurred gender discrimination, or the principle of equal pay and for equal work was in the treaty, and therefore afterwards in the directive. And that's the most important principle. And then that is further developed. And now we have around 20 directives tackling gender discrimination. Okay. Do you know what the burden of proof is? Firstly, you probably know. Yeah. Okay. So the burden of proof in gender discrimination cases means what out of these four? Who is the respondent mostly in the cases? When we say respondent, who is that respondent? We have like a gender discrimination case in work, like in your workplace. You are the claimant if you were discriminated based on gender, for example, you or me. And who would be the respondent? Employer. Yes, employer. In some cases, the respondent could be the state. We will see in cases where there are national rules which are discriminatory in their nature. Then the respondent could be for not only the state, but for example in Germany that could be in any kind of like confederation or federation. It could be on local level, on regional level, on state level, and then on the federation level. They could all be respondents. But in most cases, respondent is always the employer. Okay. What would be, we will do this. Do you know when do we talk about genuine occupational requirements? And that's the question. Which of the following best describes a genuine occupational requirement? What would you say? B? No, it's not B. Oh, there's the first time you make a mistake. There's first time for everything, so it's not B. No, something else here. There is like a requirement for a certain job. And then in which context do you think that we mention genuine occupational requirement? I will not now deal with the gender issue. I will tell you what the gender occupational requirement is in practice. Mm-hmm. For example, you want to be the priest. Can you, as a female, as a woman, be a priest in a Catholic church? So it's a C. And we will see how now it applies on gender cases. Because there is could you name maybe a genuine occupational requirement when there is required to be a man or to be a woman? Like when that is required per post, per job. Do you know maybe which? Sorry? Nannies.
Yeah. I mean, it's not the man.
Yeah. Nannies. Yeah, but that's not that's not like now you can't make it to be legally advisable to only have nannies.
But are we talking about like in traditional sense or?
This is in traditional sense what she said. But if we talk about, for example, no. What would you say?
Some of the things for traditional.
In traditional sense,
Like,
yes. Yeah.
Might maybe cleaning ladies.
Yes, unfortunately, yes.
But we are talking about
Traditional, but now the follow-up question is, what do you think it is a general occupational requirement formally? Like, is there a formal post or a formal work where you could be asked, and it is not considered discriminatory to have this occupational requirement?
It doesn't have connection with positive discrimination.
No. No, me neither. Aside from religion, now we talk about gender, for example. Do you know where maybe only one gender is acceptable, but there is like a formal basis for it?
No, I'm really curious, but
we will talk about it because this is the follow-up question, this case that we're going to do. You should pay attention. That is not like that is not put in a general notion. It's not like this job is only for men, but usually it is described as a job which is too dangerous for example, for a female to be performed, taking into consideration that, for example, women could get pregnant from the age of, in the reproductive age, for example, and then, it's always this general professional a requirement or occupational requirement needs to be very well described in a very, very detailed manner that it could encompass the fact that you are not letting, for example, a woman to do that job. And we'll talk about it. Usually that is in forces, meaning armed forces, police, military. Usually, but that's why there have been so many cases before the Court of Justice of the European Union in order to determine were there basis for discriminatory behavior or discriminatory provisions which are laid. Yes.
Question. So this genuine occupational requirement,
yes.
Is it related just to gender or just?
It's not right. It could be related to any basis of form of discrimination.
For example, when I applied for my job in the
ad or whatever,
whatever, it said I need to be Republic of Serbia citizen. Is that genuine?
No, that's like that is not occupational requirement. That's a requirement related to the nature of the job that you're going to work. It's not occupational. That's something which also was challenged before the Court of Justice of the European Union, because I wrote a PhD about it. Thank you for asking. I'll tell you the example right now because it's very interesting, and it also involves women genuinely. The most famous cases are the teacher cases and notariat cases. Usually women in, for example, Luxembourg, because in Luxembourg, which is the language that you speak, for example, which is the Luxembourgian language? They don't have their own language. They have English, they have French, and they have German, and they have some dialect, but they don't have their own language. So there is kind of an ancient Luxembourg language that exists, but that's not a real language. But there were so many cases of teachers that came from Belgium, from France, from Germany, that knew all three languages and wanted to work as teachers. But the only requirement that they did not have was a certificate that they were born in Luxembourg and certificate that de jure they then speak the Luxembourg language. So they challenged that, meaning if you have what we talked about in the previous class, if you have those four freedoms, which are fundamental of everything that happens in the European Union, and the second freedom is free movement of persons, meaning especially free movement of workers, is that something that you should use as a requirement for a post of a teacher? And then the court decided that it is, because you want to save your own tradition, culture, language that is distinct, for example, and it is, it is justified. Thank you. It is justified. The second is from notariat, because a lot of women, also from neighboring countries, wanted to become notaries. And the only requirement there is to have that you're born, like a piece of document that you were born or your parents were born in Luxembourg. So for that case, for example, it developed, firstly, the court said, yes, you need to be from Luxembourg. Now it's not that case because the European Union, as we said, developed. And now you can be born and because what's the case in Luxembourg? There are no faculties. There is only one faculty. So, for example, everybody from Luxembourg go to France and to Germany for their faculties, especially law. When I finished University of Lorraine, which is like on the border with Luxembourg, and half of them were from Luxembourg. So if you were to consider what schools they finished, they did not finish their own schools. So then the argument of tradition, of their own culture, their own legal tradition does not even exist. So that was kind of a battle, and that doesn't exist anymore. So maybe genuine occupational requirement is, maybe I would explain it to be completely attached to the profile of the work that you're doing. And then being a citizen or having, or if you're born in another country, that is related not to the profile of the work, but for example, that is usually related to the state jobs or state posts. You cannot become a mayor if you don't have, and that's in every country. You cannot be a mayor, you cannot be in a local administration, on the head of local administration, if you're not born in that country. Or in Germany, for example, if you're not born in that district. So that's
because of feelings of commute to the work.
Probably. I don't know what's behind it. I just know the role because it's still not like that is the only way. They say it's kind of justified because also you want to kind of preserve your own, not only citizens, but people who live in that city, to be governed by the people who are born in that city, district, or state. That's it.
Local companies.
Yeah.
Employ local people.
And then 7 and 8, I want to ask you. This is a very interesting case, test Asha, which we are going to do now, just now, where we are going to actually deal with the fact that before this case, pensions, but also insurance, like voluntary insurance, health insurance, life insurance, was calculated differently if you were a man or a woman. So that was the case before this test Asha, and then the Court of Justice of the European Union completely changed this, and another directive was brought in order to, I would say, underline that principle and implement it in the member state. Also, this work-life balance directive, it's called very nice work-life balance directive. What do you think it introduced? Because it's called work-life. So it's just for you, what do you think? So is it maternity leave? Is it non? Yeah, it is B. It's maternity leave. So the word here only does not stand. So it's maternity leave, but also not transferable paid parental leave, because before it was not regulated as parental. It was just maternity leave. And afterwards, now we'll also deal with some Court of Justice cases where it is equally important to leave a man and a woman who just had a child to have the right to a parental leave. And also, what do you think, when are positive actions? So we're going to deal with the case, but what do you think when positive action, this is what you mentioned, when you encourage positive discrimination, meaning you give some kind of impetus or quotas for women, when is it permitted? In which cases here? Yes, and we're going to deal with each of these conditions because it needs to have, we talked about it a little bit in the previous class on Saturday, it needs to be really proportionate, and it needs to take into consideration that both men and women were equally considered and they were equally qualified for the work in order to give an underrepresented sex and its stated sex, I would say, preference for a certain post or vocation or any kind of other training or maybe even schooling in some cases. Okay, we're done here. We're going to start with the presentation, hopefully. Da li sam otvorila tu prezentaciju? Jesam. Let me start. Viš sad kad neće mi se vidio ovaj share? Jo. Evo. Ajmo sad share. Znači, kod Dragica, kako se ovo širi? Evo, ne radi. Jel tako, je bilo to? Ja, sjajno. A zato što, jel zapamtila je ime Dušanki i to je to. Pa i ja se, tako i meni. Lovely. Tako se, ja sam kod nje istišla na master. Kad sam imala 22 godine. Evo. Okay, this is what we're going to go through. And I already mentioned this. This is something that you would need to remember from previous class. These are the most three important institutions which are involved in the legislation part, meaning the European Commission proposes legislation, and then you have those two institutions which adopt by co-decision. Okay, this is not for you now to read. This is what I am telling you, like I'm telling my students. I'm making this detailed presentations in order for you to ease up when you want to study. So nothing you need to read right now. This is uploaded on Moodle, and then based on these presentations, they are sufficient for you to prepare any kind of exam. Like everything I put online, I think that's sufficient. You don't need to look for any other source or anything I've talked about. So what you need to remember from today is what I already mentioned, what is regulation and what is directive and what is a decision. We talked about the decision. This is the triangle or the pyramids of the most important EU sources. And we're going to deal, of course, with the middle, because the middle is the most dense one, meaning there are so many legislation acts that I don't even know them. And I mean, I dealt with them in different jobs, and you are never, ever going to be able to memorize all of them. Don't worry, never, ever. I don't know their numbers. I remember their numbers. I always have one word that reminds me of which directive it is. And I think that only people who work in bureaucracy, meaning only in the European Commission, because the Commission is the one that proposes documents, are the ones that know the directives by heart. And I never ask from students to tell me the name of the directive in full or to give me the exact 2006, /EC, etc. That's nothing important. I just need to know maybe the year and maybe something that you can relate to that directive. This EU regulatory framework is something that is policy, meaning something that is not obligatory. And the most popular one, I would say, with Ursula von der Leyen being the president of the European Commission, is the one that I sent you, I think, in this email, and that is gender equality strategy. Meaning that having in mind that she was the first president ever of the European Commission, she wanted to introduce a complete, I would say, a very detailed policy that will give the guidelines not only to EU institutions, but also to member states, but it would also initiate the entry into force or drafting new directives. So sometimes from guidelines, meaning from soft law, this middle can be produced. So it means that firstly, you figure out the guidelines and you figure out what your goals will be in the I would say, following 5 years, and then you produce directives. The best example for that is, and still is, it's when Ursula von der Leyen introduced this EU gender equality strategy in 2020, she said that European Union is going to be acceding to the Istanbul Convention. You probably heard about the Istanbul Convention from professors. or in general, but also EU is going to introduce its own directive that deals with violence towards women and children and family-based violence. So it was introduced through soft law, but afterwards it was brought and the directive entered into force. Another directive that we're going to do today is women in corporate boards, meaning very big shot women who are CEOs of the biggest companies in the European Union. Because as you would imagine most of CEOs, directors, and executive directors are men. Only 30% nowadays. Before it was, I think, 10%, 9%, etc. You're going to see the difference. Were and still are women. So there are women. There is kind of gender parity when we talk about lower paid jobs, or maybe some jobs which are in the middle. But when you go higher and when you have more paid jobs or the best paid jobs in the European Union, it's still a very, very strong glass ceiling. I wouldn't even say a glass ceiling, but a ceiling, which prevents women to have that position, even though they are equally qualified, as we mentioned before. So we went through this. We don't need to. This is for you, a cheat sheet to know. Okay, this is what I asked, and then Alexander replied. This is the difference between direct and indirect discrimination. And this is just for you to have it, because it could come up as a question. This is like one of the questions which are kind of very often asked during the exam, because then they will ask you which are the most important international sources that deal with this direct and indirect discrimination, which are the most important European documents. So you need to know the basis, the difference between indirect, direct discrimination, burden of proof. But we're going to go through that again. The most important goal of each directive, but really of each and every directive, is to harmonize, not to equalize law and legislation, but to harmonize, meaning it's setting the minimum standards that need to be met in each member state, which we talk about as well. We have a goal. That goal is a minimal standard, and then the member states should reach, upon the given deadline, that standard. What happens if they don't? For example, what happens if a state does not implement, for example, directive women in corporate boards, which should be enforced until 2026?
So they need to have a reason why we can do it.
Okay.
We will set that reason.
Okay.
If it is in order,
Okay.
they will not pursue they will not go to the
Okay.
And if not, they will, and then it will be brought.
Who is the institution? Which is this? Not who. Which institution is the responsible one to monitor a commission? So they're going to explain to the commission why
They will issue a report. Follow up of that directive, and that's the way.
yes. What happens if they don't? Again, so they do everything. Brought to court, right? So there could be, and that happens a lot more than usual. That member states that did not. There are two cases that did not implement or did not properly implement.
This was my last exam. That's why I know.
Which one was your last exam? Political system of the Perfect. You're the only one who ever actually answered that in my master course, but at the beginning, not at the end of the year. Okay.
No, it is the last.
Yeah. Okay. So you remember. So the remaining colleagues, I guess you know something about the thing is, I would say 5 most important things from the very accurate description that you gave is commission monitors. Member state needs to state the reasons. The commission is the one that sends the letter actually and demands the stating of the reasons, and then the member state explains, as you said. And explains, meaning that the Ministry of Justice and other ministries explain the reasons why it's not implemented. Then the Commission gives them an extension of deadline if it is, of course, justified, and then they need to do the follow-up. But if they don't implement it, or as I said, if they do implement it, but they do not do it properly, meaning the legislation, national legislation is not good, meaning that not every provision of the directive is covered in national legislation, that is also to be brought before the Court of Justice of the European Union, either, most usually by the European Commission, or there could be other member states that could also sue the other member states for not respecting the rule of law in the European Union, not implementing, because if you have some very strict standards, and for example, 20 countries implement those standards, and the remaining 7 countries are like playing deaf, meaning that they have maybe better rights, or not rights, but they have like, that's usually the cases with pollution, because of course, some states are very rigid regarding the environment, and some states are really, really, really pushing it through. And for example, Bulgaria, Romania, Hungary, etc. They're usually brought to court not only by the Commission, but other member states which did implement are playing by the rules. So that's how you try to harmonize standards in the European Union.
What about the harmonization for the
candidates? You can only pray. I'm kidding. What about the candidates day? And I work in the government, so I'm trying to find a nice word. Yeah, that, like, you can write a report. I mean, they write reports, as you read, probably European Commission files the report, not files, but the European Commission publishes the report on every candidate country, where it is stated everything that is not going well, everything that is stalled, meaning not moving at all, and everything that is a positive breakthrough, which is very rarely with us since 2016, unfortunately. So bear in mind also that a lot of things are not working well with us and our progress in the harmonization, but also what I'm very critical about, the harmonization process is so burdened and overburdened by political issues. So even though you are, for example, working very hard in one domain, and you did make some progress in one domain, it's going to be stopped or stalled by some member states or the whole group of member states because of unresolved bilateral issues, political issues. For example, in our case, it's the issue with Russia and Ukraine. And of course, the territorial issue, which is, in our case, Kosovo, which I completely think that there is not a single case in the European Union that dealt with Chapter 35 that is with us.
I have a question, and it's related. We were just recently at a meeting for the progress report, and the money that is found for just finalizing the progress, reform agenda, and the money that is promised, if you check the box, is really enormous. But how do they know that the thing that they promised is done, but in the best possible?
If it's really implemented in terms of like you adopt a law and it's formally
really substantially. In which domain would you say?
Yeah, for example, they promised they will pass the law on anti-trafficking.
On
Anti-trafficking.
anti-trafficking. They did not, right? We don't have it.
They will.
They will.
They will. Money that will be. Yeah.
Well, yeah, the revisions that we have amendments, right? That's I would say that's one of the most difficult things to establish, because if you take the example, even simpler example of the amendments that we have on our constitution. So those amendments, as we all know, were very much discussed in public, and some were very pro and some were against, some were in the middle even. But what happened is, like, the European Commission really accepted those amendments because they were just looking on the formally checking the box. Okay, you did these amendments, we are going to accept them. They did not go into substance. And that is that's the mistake of the European Commission. And that's why they have Hungary and Poland, for example, with a non-functioning judiciary or with very, very big loopholes and gaps in the functioning of their or retroactivity of the laws and legislation, etc., regarding judges and prosecutors, etc. Because especially in 2000s, when there was like 12 countries at the same time during their harmonization process, the European Commission was only looking on ticking the boxes. And that is now a little bit changed. It is changed with, for example, rule of law, because they realize that the rule of law is deteriorating in every country possible, except, for example, if you take Sweden or I don't know, even Sweden. No, but for example, Federica Mogherini who was she was in charge of the foreign affairs of the European Union. She is arrested. So, I mean, there is like the rule of law deterioration everywhere. And they come up in the previous 5 years with the rule of law checklist, which will help establish and evaluate if the rule of law is substantially respected and promoted by a candidate state. But it's very difficult to see, because what we see in the progress report is always only to the level of entry into force of a law or a bylaw, and then certain level of implementation by reports when they get the stats, when they get the data, but the data are not always correct, not very well founded, etc. So the implementation, we can never talk about the implementation. They can see, and that's like the easiest way to remember how they see if the law or legislation is implemented well enough. If we have anti-corruption laws, and then they see if the number of cases regarding the high corruption cases, if it's increased, thank you, then they see that the courts very well applied, and not only the courts, but against anti-corruption, etc. They applied the legislation properly enough in order for the increase of the legislative procedure in those cases. That's the only way they can establish that. In that way, they also need to have a very good level and knowledge of each candidate country, because everywhere is different. And what they do, and now I'll go back to gender-based questions, they apply, that's also the mistake of bureaucracy, they apply a one-size-fits-all principle, meaning they will monitor the same way Bosnia, Albania, Serbia, and Montenegro. And we're coming from the same legal tradition, legal families, even our laws are very similar or taken. For example, Montenegro has 90% of our laws, but we are not the same. The context, the political context in which it is implemented, and not only the political, but social culture, judicial culture is different, and they need to take that into consideration. Usually they're not, and those are the two biggest mistakes. So I call them, in my papers, I call them window dressing, meaning you're just looking at the window if it's nicely decorated for holidays, and then after the holidays, what happens inside the store is what you're left of, right? I mean, that's our biggest problem, but that's also a problem on the other side, and that's why there is like a lack of the Euro optimism everywhere. Yeah.
Can I have another question?
Yes.
Sorry.
Thank you. That's actually my primary, what I'm dealing with the EU law, but those are the words.
It's related, but also not related. So it's about the Council of Europe. Serbia is a member state. We are obliged to also harmonize some.
Yes,
right?
yes, conventions. Yeah.
So what happens then if we don't do that? In a case, for example, for registering with the physics partnership,
we're again monitored by the Council of Ministers and their departments, and then they write to our institutions and the Ministry of Justice. Then the Ministry of Justice needs to explain why we have not yet implemented, because conventions are usually need to be ratified and then implemented through, as you know, to become the part of our legal system. And usually the Ministry of Justice responds, and then we wait for an additional deadline in order to implement that. And
that's really slow, even when you have a court decision on your country.
Yes.
Serbia.
Yes.
Serbia dealing with state partnerships. We don't have that.
Yeah.
even that then it's low because we have a lot of judgments. I know, for example, for missing babies and stuff.
Yes, yes.
But the execution, nobody.
But there should be 6 month period.
And then that's the question. Then what? Then the country could not be. It could be held responsibly, but first it could be held responsible in a political sense. That's
But related to this topic, did that happen? Did they go to the ministry and
yeah, we had to respond for missing babies. Our ministry was in correspondence with the Council Minister of the Council of Europe, but I don't know what happened. I don't know what was the follow up on that. What happened afterwards?
I can tell you that
Yes.
So you have yours, you take your side, and then the government should stay their side.
But did that happen?
Yeah.
Yeah.
Yes.
And what did we state?
We stated that not any legal remedy is used because we didn't use the Commissioner for Equality and Ombudsman.
For the European
Court. Even though we went to the Constitutional Court. So, but
Okay.
These two were true.
But then you can prove.
In additional cases,
Yes.
that is with the remedies,
Nothing would change, or the situation would be the same.
Question on
Yeah, but
yeah, it's a new commission.
Come smeta jak Milan Antonin. Let's go on equal pay directive. My first internship was in Belgrade Center for Human Rights in 2010 or 11. That was my first with Kuća ljudskih prava. Yeah. Yes, that's why that was my first one. And then it was in praxis dealing with Roma, and then afterwards I passed through. Yes, and then I passed through EU. This boring stuff. So yeah, I did NGO first. I always wanted to be in an NGO. Okay, let's go to the Equal Pay Directive. So yeah, I'm going to go really fast through all these directives, as I want to only enhance or underline what's the most important part, which I did very as a geek. I did it as in the previous presentation. I always underline, and with the marker, I do like what's the most important part, which you need to remember from each directive. So as we talked about, and what you need to know, the first one was always in the 70s. It was the Equal Pay Directive, which followed the first treaty article that guaranteed the principle of equal pay. Why is this important? Because of the last two phrases in this yellow part, and this is you now have the right to pursue your claim by judicial process after possible recourse to other competent authorities. Meaning, this is the first time that the EU guarantees that in each member state, if you are not equally paid for equal work, you have the right to call upon that directive and go in front of your member state courts and say, yes, my rights were not respected in accordance with this directive, which had to be implemented properly in the national laws. Furthermore, those two. First one is Equal Treatment Directive, and the other one is Equal Treatment of Men and Women in Employment and in Occupation. So the only thing that you need to remember that the first one is more general one, and it was brought only a year after Equal Pay, Equal Work, it's 76, and it guarantees, as I mentioned in the last class, not only employment, but training, occupation, and working conditions. And there we go with the occupational requirement. The second, which I underline in yellow, it goes, this directive does not apply to occupational activities where by reason of their nature or the context in which they are carried out, the sex of the worker constitutes a determining factor. And now we need to figure out where the sex of the worker constitutes a determining factor.
I'm not.
Oh, I got it. The directive does not apply to occupational activities, and then including training, where by reason of their nature, that's the most important part, where the directive does not apply in the same way. We will go afterwards. That's the case that we're going to deal with. Now I'm going to just mention that one, and then we're going to have a break. The second one, this recast. When it's written recast, what does it mean? Recast means the directive that actually just, how would they say, upgrades, how ažurira the other one. So recast directive is something that we already had, and now we're just upgrading it. So that's the recast directive on equal treatment of men and women. And here it's actually the first time, and this is very important, this directive actually mentions for the first time not only sexual discrimination, meaning the discrimination based on sex, so not gender, still we're not up to gender, but it introduces sexual harassment in work. And this is the first directive in 2006 that deals with sexual harassment, not only in workplace, but when it comes to employment or any kind of other aspect. Yes.
Does this mean that the first one
No, it does not mention sexual harassment.
No, but because this was the recast.
Yeah, we don't use the 76 now. No, yeah. Recast, we always look at and now when we talk about the equal treatment directive, we talk about that one. So it's 2006 directive. And that's how you learn it. Equal treatment directive. You don't need to know anything else. You just say equal treatment directive and I will know what you are talking about. So, and this is like one directive that encompasses several instruments into one that deal mostly with employment and jobs, but they also deal with, I would say, a broader perspective where men and women should be treated, still men and women should be treated equally. And now we have a break, and then we're for 10 minutes break because we want to finish early. And then we're going to deal with the case law. Okay? So 10 minutes break now also for the online.
That's okay.
Yeah, okay. And then we're going to deal with the case law.
Imamo dva slučaja, nova su dobro su godine, ali kao na tekstualnom sudu. I to je posao kod prvi poslati namoru, drugi, ja mislim, majke, to je bitno nešto. I država odgovorila za onaj prvi, i tu je kao koristio poverenicu i majka kao legitimno.
Dobro, kad je bila poverenica, mislimo šta možda...
Da, da, što kažu da ti izvini.
Da,
Što je na Ustavnom sudu bila mi žalba kao u toj odbijenici stoji da nije uključeno njeno manjinsko pravo, je kako se da neče. I mislim, ali ono što je interesantno, je
da je vezano za brak.
Mislim, ne možeš ti ideš na zajednicu sa branicom svoju, ali nisam kao piše u Ustavu da je brak zagarantovan pravo svim građanima. A onda to je da je brak između muškarca, ali imaš ovo svima. I stavno kao niko nije išlo za to, nego po međunarodne obaveze, ali mislim ono, i da bude nešto, može samo da bude kao da
Moje
voli
mišljenje
nešto,
nas
ali
iz
neće
Italijane
ništa.
sada pitaju, znaš što desilo, ali mi kažu nije, a oni pitaju državu zašto, država je nikakvo rješenje kaže.
Tako i u Bugarskoj, tako i u svakoj ovoj zemlji koja ima nešto. Pa jest, da oni očas, ali bilo je interesantno. Pričala sam sa ovima iz Sođeja klinika, projekte Evropi, oni su bilo kako će da biti. No,
A čekaj, u moje državi. A čekaj, znači, koliko se vodila onda?
te žene su otišle kod matičara da se nađu. I onda je matičar uvidio da su dve žene u pitanju i onda je rekao mi ne možemo. Žene da će vratiti na muška.
Da, je li izdala, šta je izdala rečenje?
I onda je na osnovu rješenja i ste išla na popravnicu, pa onda
To je kako?
znači, već su 2000
Inače od ove godine.
ove godine.
A ne, ja rekao od ove godine su učine povanje. Ja ne znam su.
Imamo 2017. A Karol je 2018. sa tako da realno ću računati da će da govori u 20. Ne znam koliko mi treba generalno na trenutku. Jer to je već poznato. Tako da ne znam. Mogu sam rekla. Morala sam kako se dala. Nije pripa. Ne bilo. Rekla ću stvar. Bori pratite. Je informacija. A ovo je...
Ja sam čitala nešto šta pišla neka ministra preko Bakarova i sada ministra kada je bilo oporaviti. Željela sam i dalje u mandatu zavetnice.
Ja sam čula će vam biti radni grupi u
Pitam se, i menja se stavljeno moje ne, šta te je duše produktivna. Znači, tu vam pa trećem po bojku.
da Vojko svoje kući. Ja ću da te postavim ko se prijavio za IRS i odmah. Da, mislim, ove nedelje, nego...
No, se vidjeli malo.
Periš.
Što tako biti može? To je dan, označilo sve. Je četvrti po redu način izvršenja. U Srbiji. Kako je tamo Srbija? Treće silovanje.
Senzoma. Bukvalno kao... Znači, ovo su organizacije. Centar za pozitivni razvoj dece nacionalna organizacija osoba sa invaliditetom.
Onda postoji sa kvalitetom su ono, privolani da bude ono. Ja, držam šulu.
Udruženje žrtava nasilja HAJ. Deca bez granica. Centar za razvoj i edukaciju toga.
Ti našla ovdje. Nije čula.
Asocijacija samih ovo je rana grupa za izmjene politizata.
Kako gledam da buči.
Možda sa udruženje
Ja, je točno da bude što...
ne uvijek.
Da znam, možda...
Tako da, baš da nikog nisam čula. Ja nisam
Malo simptomatično.
Ne znam. Ama da nikad sam htjela da je probao, pa nisam to znam, ali teško. Što učiš za diskriminaciju?
Što je naša prava, pa je da, ne.
Prima rekao sam nastavno bila presude Europskog suda prava i one zajednice da Srbija mora da uspije to, ja znam
To znamená, že Azerbejdžán nezachytil a to že ty pochopili problém sa neizvršením. Da, mi smo potpuno Gruzija i Azerbejdžan i to nisi to moja advokasi kao vidite, Savet Evrope se počustuju cijenu. Da.
Pa ti možeš da tužiš nekoga da kao privatno.
Šta onda?
Ovo je na Europskom sudu. Ne pa kao neke te izjavili su. I onda ti tužiš
Ja mislim da moraš nekako državu da...
Ne, može biti privatno. I da ako država nije prepoznala to kao...
A tu ti isto da ide protiv države. Da. Da nije prav ili nije država ispred. Ti vidiš da to je fizičko lice koje je radnica tako da. Da stanu državu možda.
Znači, ako država nije obradila.
Nema. Bara mi predsjednica na ovom mjestu.
Znači, tako. Da se spremim. Što mislim, ono kao...
Ja to sam čula, ne bih znala. Oni nešto. Kaže, koleginica Milena, što je bila da je bila na konferenciji u 16. Nije bilo. Kaže, mi smo obrazovali koliko Roma, mi smo ismenili. Ne, pa ne.
Samo što je, znači oni se nalaze u Beogradu, ove Lane, ne, Jana, je li Jana ili Lana? Ne. Jana. Ne.
Ne, vi svaki ne. Nisam ovo navikla. Nekako što dođemo nekako izađemo u fotu.
Kako se pravi, mi smo nadali do 3. 5 sati i više nego dobro.
I ovo je da to je ponovno što je on. Larici je bil parno i stavio 4 do 6. Igrala javnost kolegi. Šta bi te nije vrata da ode kući da stavio. Ja, ako ne budeš tebe kad dođemo u 9, sad imate. I to dođemo u 9:00.
Ja mislim da se vratimo.
Pucamo, ali navodno Ali moram da se putem da bi ušla da se da. Imam ovdje imam dve, jedna za... Znači, ova je za ulazak na jedna vrata, samo a ova je za sva ostala vrata unutar zgrade. I, na primjer, rekli su mi, ako neko sad otvori vrata i prođe, ne sam ja da prođem zajedno sa njima, da moram da se otvorim, pa da prođem jedno do vrata neće.
A nije se taj kartica ima tvoje ime, osim ove koja mora.
Zato što me zvao čovjek na telefon, ovaj poslovnik, zvao me da mi kaže da moram da se putem jer imam na kompjuteru, nema šta da radi, tako dala, sedi, on zna gdje se tim svakom minutu. Onda me zvao, ovaj mi reče svi kao ja bih hoću telefon da ga on mi rekao, možda da ga u gradska gdje se ide, pisao članica, da se daš čas i sada ti čuo telefon za toga. A on to je kod kolegi mi rekla, možda da čujem, mi ga ne raštimo, ovoga šišća, da kako te plaćamo. Ja ga ostavila, svi akadema, ja ga ostavila i očuva nešto. Odgovori, da vam što po se dok što gleda na ekranu te. Koliko novinja. Dobar dan, rekao, da vam što po se rekao, ovog broja, ne znam kojom kao. Koleginice, Milan Radić je ovde, znači, imate propušteno, imate dva. Vidite kolega koji je na treningu ovde, da treningu ste, pa da onda izbiti, onda kao u redu. Inače, naravno se glade, taj čovjek, koji se zabavaju svi, ne svi su kao, koliko jete što se ti primaš oko njega, a on da se ima kako ti ima, on se ne zna. Danas kako se mi dašla da sekretu? Neki djeva, znači, proganja me.
Ne, svaka čast, treba.
Niko da ne zove, to ne, kažem ti, to nije da se uzao meni.
Samo ti nemaš što na tom.
Znam, ja sam špenčak sam zašpičak. Ovo je našoj Ivaničić, naravno, sada mi uvijek sam živjela ovo. Mislim da je na to. Je, kamera. Ja sam bedove, ne znaš. Ništa, rekao mi je, da ne idem da procenim, da ću da se izgledam kao, od sad pa na dalje ne sve kažu ništa. Ali kao na meni da procenim, da ću mi istoriju da prišem. Ja sam mi da kažem istoriju. Pa nisam pisala. Nije me kao na pamet. Da bi baš nisi
sam da ne mora samo politiku.
Ne, koliko sam ja shvatila, jer ja imala za njim jedan na jedan, on je security, šta? Da ne drži predavanje o svim tim stvarima, to je prvi dan da dođeš nešto njega. I ja koliko sam shvatila, ne meni samo rekao da ja ne znam ništa politički, ja ne kao mediji to mogu da spinuju, da osprenu, da ono. Da, kako gledam da se baš
ali mislim se došlo da politiku. Mogu da se malo bilo, pa će kako vidio ovaj napad.
Ali malo smo inicipali, ne znam što sam dopustila da mi uđe u podcast. Bilo sam brala koristam Instagram i sad imam reakciju da brzo lajkam stvari. Kao vidi, nešto ima što se desilo mi se da lajkam, neke stvari je dobro stane mi kao je, sve da lajkujem, znaš. I onda je nije samo bilo. I što je malo bilo da... Mislim, a ja sam pristupo još što mi nazvali kao unlike.
Kao pravaška međunarodna
Pa i ovo da mi kaže ne znam da kači bilo je moj pilotan profil je mogu da kači
da ne vidiš negde napolje. Ne znam.
Moj mene znači da neću da gledam u vladinu kada se i naravno ovo je tako neko u Mladenovcu i
সার্বিয়া থেকে ইনভিটেশন দিতে হবে এমন একজন ব্যক্তি যে ব্যক্তি সার্বিয়ার ফ্যামিলি মেম্বার। এমনি ইনভিটেশন
Jao, Bina, izaći. Nije da me nisi slušala dovoljno u životu. Da. Pozvaću vas da dođete na konferenciju kod nas u... Kad nam je konferencija? Hoće da dođete. Utorak od 4. Još jedna obaveza. Ivana Krstić organizuje konferenciju Istanbulska... Da, okej.
Ali agenda nije potrebna, i nije zadovoljno što ja ne došla. I rekao je cukrovicu te prva stvar, tako da dobijati agenda.
Ne treba da mogu, 2 sata. Pa ne, ali lepo je da vas vidim. It would be nice to see. Da? Eto, ali nije od 4 do 6.
Da, baš ćemo biti jedno. Iako mora do 4 da bi Dragica.
Ide prvo Dragica. Znači dužicu, crtica Dušanko u prvi red. Dragica dođe. Dragica je obraća sa Dušnice, jako je Dušanka, ali we all been through that. A u pero. Ja ću se da rastajem. Evo, let's start. Bye bye. Thank you. Hvala što si me dopratila. Zdravo. Ok. Let's resume. Ne, ovo je bilo. Evo ga, a ovo je sad. I ne snimam. I don't record any of the lectures. Don't worry, that's only Professor Dragica who is recording. So everything you say here won't be used against you. Don't worry, nobody listens to that. You would know if it was recorded. Okay, let's resume with the general occupational requirements. So this is one of the cases that was one of the first cases where the issue of occupational requirement regarding gender, regarding actually the post or the occupation that should have been occupied by women was occupied by men. It happened in Northern Ireland, and you should pay attention to the year where it happened. It was 1984. Do you maybe know why these years, this decade was very, I would say, delicate in the political context for the Northern Ireland? Yes, that's why. See here, I can read it to you as you're very blurred here. So the issue was actually whether a woman could be excluded for a position of a full-time, as he will say, a police officer, meaning, but she was a reserve police officer, and she was a constable. Constable is something like a higher than like a general police officer in Northern Ireland, because in that province of Northern Ireland, it was prescribed by the chief of the police, and he can, because there is in Ireland and in Great Britain, there is a system of precedent, meaning that all any institutions and also bring rule books and other documents. So it was prescribed by the chief constable that women police officers should not be armed. And what was the excuse, or actually what was the reason given behind that? Was, and it was written here, that women might be targeted for assassination and their firearms could fall into the hands of their attackers. And then the attacker could use this firearm for the further conflict. So it was too much for the ideal of an unarmed police officer and an unarmed policewoman. So they considered that it was better for a woman not to be a police constable because she could not carry a weapon. And it is more safe than to have a woman that could not carry a weapon. So actually they deprived her of the right because she should not carry a weapon. And it was written here, see here, and that armed policewoman, and that armed policewoman would be less effective in carrying out welfare work with families and children. This was kind of very, very problematic. And so this was before the Court of Justice of the European Union. Mind you, in at that time, it was not the European Union, those were the European communities. And this was 84, and Great Britain was, and United Kingdom, was only 5 years in the European Union. So it's kind of in the European community. So it was kind of new, freshly new. And the question of discrimination, specifically this kind of gender discrimination based on occupational requirement, was not very much elaborated. And that's why that was the decision. So the Court of Justice considered actually that the nature of the work as a police officer did not constitute a general occupational requirement, which we all agree. This was evidenced by the fact that the law expressly stated that the principle of equal treatment extended to the police officers and police arms. So, however, this is important, the court was prepared to accept that the context of policing activities, especially in Northern Ireland, constituted a determining factor. So here, the first part actually gives you, I would say, like a prelude for further court practice, but the second part was only regarding the public safety in Northern Ireland. Do you think that that was a reason enough for these kind of professional occupational requirements? So we wouldn't know, because in the 84, we didn't know how dangerous it was in general to be and how serious were those conflicts and everything else that happened in Northern Ireland. So we did not know, but probably they have taken into consideration, for example, how many conflicts happened and attacks towards police officers, etc., in the previous years. But for me, what was more important was the first thing that the court considered, and that was that a police officer is not, to be a police officer does not constitute a general occupational requirement. But we go further. You now have the assignment to pick one of those three cases and to find it online right now. So either Picker Crail or Commission versus France or CIRDA, and tell me what was the most important part. This is also regarding general occupational requirement, to see what was the issue here and what did the court decide. I always put all the info. You don't need to know all this info. I put it because of your search engine.
কত? 500 টাকা আছে।
You realize that I gave you armed forces everywhere where women were generally in armed forces. I think. I don't know what you picked. What did you pick? versus France. So you too. But somebody has to pick something else as well. Commission versus, great. Everybody picked Commission versus France.
Right.
Yeah, I can see.
Right. I don't that let's divide that task between ne, i te vrlo često izmisli ručeve, da.
Ne, ovo što mi našo nema, znači neki poljoprivrednici u Francuskoj
Ne, mora baš broj da se kuca, zašto postoji mnogo slučajeva. There are a lot of cases, Commission versus France.
broj i ovo na kraju. Jedan kako da puta radno sarski. Ovo je stančarki oruvate.
Yeah. Did they actually use the pen inside and outside? External affairs and internal affairs as the ones who were not at that time considered under the scope of
Defense is never actually considered in the scope of the EU. That's since the 1950s. So is your question related, is defense somewhat related in the scope of competences of the EU?
No, they used because it wasn't a part of it as it was
Okay.
economic, whatever, for not intervention.
No, they did not use that argument. You know why? Because well, this is kind of divided because it's considered also jobs, meaning market, meaning industry. So it's not only armed forces as being, but it's also armed industry, which also forms a part of the market. And then it could be used. It could fall under the scope of the European Union. If it was the Ministry of Army or our minister, it's not if it considers political decisions or everything else, or if it considers state posts. But if it considers, for example, this military roles or factories, etc., then it's considered by the European Union. Let's start with Commission versus France. Okay, maybe that's the easiest. What happened in Commission versus France? Not with the agriculture thing, because there were a lot of cases regarding agriculture, right? But what happened to Commission versus France in 1988? Do you know?
So and before the court, because they had a general norm.
Okay.
That would women from not just security, but also administrative and order. And that was also the problem because it was not regarding one particular job or one particular occupation, but a lot of them, and they said that they didn't practice and they discriminated.
Yes, this was, thank you, and it's correct. Firstly, this was the issue of why did not France implement directive properly, and that directive at that time in 88 was Equal Treatment Directive, but not the recast one, but the one from 76, the first one. And the French law, while implemented, yes, you correctly stated, used very general and vague sentences where they excluded women from those public service positions. That was not only combat positions, but those were also police, firefighters, etc., etc. And what they missed to do, what the Equality Directive actually asked them to do, is to assess case by case where there is occupational requirement justified, and they did not. Plus, sometimes, as it was the case in Northern Ireland, sometimes occupational requirement is justified just in the context of the case during a short period of time, but it needs to be periodically reviewed. So sometimes it could be justified, but after some period of time, you need to review it and to justify if or to verify if there still is necessity to have an occupational requirement. France did not do either of those two things. So they had two general sentences, erection provisions. And secondly, they did not have any periodical reviews. So the court reasoning was the following. So they thought that those general exclusions were firstly disproportionate and secondly contrary to what was said in the Equal Treatment Directive, especially because there was no proof that women generally lacked aptitude for military jobs, for military service in general. So in order to put such a general provision, you need to have a proof that generally women lack any kind of physical, psychological, or any other requirement they cannot fulfill, but men can. And thirdly, as I said, it was not regularly re-evaluated. So that was the mistake that France did, and the outcome was that France was to amend its own laws in order to have a strict scrutiny when occupational requirement is justified and demanded. Okay, and what happened is in the other two to be breached, the Trail and Sirdar.
For the Trail, she was a chef. Like in cooking.
Yeah.
She wasn't a part of army or any force, and she wanted to transfer to the Marines, and she couldn't transfer to the Marines because everyone in that race, needs to be combat ready, and because she is a woman, she is not a combat ready, even though she wanted to do the job of a chef.
Okay.
And as if I understand it, the conclusion is that is okay.
The Court of Justice said that it was okay. What, to ask that or not to?
The unit's nature and the needs to guarantee public security and combat effectiveness.
Well,
it's excluding women.
Yeah, but here I think, as what I underlined is what you said in the first part. It is true. Sometimes the woman can be prohibited from serving certain military posts, which involve the use of arm. But for this case, it says here the court maintained that this directive, as you say, Equal Treatment Directive, must be interpreted strictly and only proportionately, to derogations which are appropriate first and then necessary to achieve the aim, and the aim has to be justified. So in this case, this directive cannot justify special protection for women against risks which men are usually exposed to, because she did not want to do that post. She wanted to be involved in different kind of posts in the military. So in the first part, they say that sometimes it can be justified, but in her case, it was not. And what happened in the Sirdar versus Army board? Did anybody find the Sirdar versus Army board and secretary?
No, I that's what.
Ah, okay, because that was okay, yeah. Okay, so yours was Seder. Okay, okay, then I understand.
Germany, she wanted to be in the army with
To use firearms. Yeah.
All the is allowed to be in the army except medical staff.
Yes. And she wanted to do the electric maintenance of weapons, etc. Yeah. And then
they said it's not,
the German law was not compatible with this 76 directive, also based on the general basis, because they had two general provisions and it was not compatible with the equal treatment directive. And then this was actually your case. That's why I was confused. What was the outcome? Like, okay. Let's go further. This was the burden of proof directive, which now you have. Firstly, this appeared as a special directive. This directive was in '97, and this directive actually firstly shifted the burden of proof. And this is what I underlined in yellow in the first paragraph, and that is the most important part. The second sentence: if a person alleges gender discrimination, and bear in mind here it says gender discrimination, the employer must prove that no such discrimination took place. Here it said employer, because as we spoke in the beginning, it is usually related to work or occupation or anything related to professional requirements. This change provided stronger protection for individuals in the member states. And here I actually copied for you the burden of proof article. This is the only article you need to know, this Article 4. So everything else, I will never ask you, nobody will ever ask you regarding the burden of proof directive. So you need to know this Article 4, which actually establishes who is to prove if the discrimination took place and how it happened. So these are the necessary measures.
Directive that mentioned gender.
No, I'll tell you which one. We'll do that in the. And now we go to this Badek case. This was actually interesting enough because those were the men who challenged a certain German law. It was a state of Hessen in Germany, and it actually had positive action measures, meaning not quotas, but positive action measures in order to promote. And the as you see, it's 97, so it's more than I actually said 20, but it's basically 30 years ago. So in order to challenge posts where women are underrepresented. And here, it's very important just to see this phrase, which I underlined in pink, what happened there. So this state law of Hessen in Germany actually reserved at least half of vacancies, meaning the posts which are free to be occupied in training, hiring, and promotions for female candidates in underrepresented sectors. This is also important. So where you need to find out in which place the underrepresentation exists. This is the first one. The second one, they need to be equally qualified. You cannot give automatic preference to either of sex, in this case, sex. And then this law, as you see, it has historical kind of I would say weight, because it wanted to ensure a substantial equality, because the formal equality was guaranteed since forever, but this was the way to deal with substantial equality. And then fast forward to court reasoning, the Court of Justice ruled that the Hessen provisions are compatible with EU law. So the man challenged it, and the court says yes. Why they're compatible? Because, as we say, it was an underrepresented sex. In that sector, it was obviously underrepresented. And thirdly, it was not an automatic exclusion. And it was an exclusion of a better qualified candidate. And it was based on sex. So it was something that's actually paved the way for positive action measures to be introduced. And this was one of the first cases. Two of them we discussed in the previous class. Those are the ones that I also asked you to Google it. We have it in the previous presentations, and this one is the one in 97. Now, why do I talk about this one? Equal treatment in occupation and social security, because this is interesting enough. for pensions, for benefits and retirement, women were not treated equally because of the risks that they considered were only related, for example, to women's health or women's age, etc. So this was the first directive that changed that. The second one that we want to, or what the 10th one that we are mentioning, is this parental leave that will later on become this work-life balance directive. So the first one that was introduced was the one regarding the parental leave. What happened there is men did not accept it very easily. They did not use it, even though it didn't speak anymore about the maternity leave and about the mothers who are taking in charge the whole role of motherhood when the child arrives. Men were not really willing to accept the paternity leave in general. So those were kind of, even though this directive was brought, stereotyping was still very present. And now, why do I talk about this one so much, even though I only underlined the first paragraph? Because when you talk about the directive that deals with access to goods and services, you immediately think, what is the difference between men and women when we want to access certain services? And the first paragraph actually gives you the answer to that. Because goods and services is everything, starting from health insurance, starting from any kind of other, as I said, life insurance, and thirdly, financial services. As you know, in some countries, completely banks and other financial services had different regulations for men and women wanted to take credit, wanted to have a loan, etc. So this would cover this scope, the whole scope of one of the core freedoms, and that is free movement of services, and another one, capital, which needs to have also women and men who are free to choose services, but they need to do it on an equal basis. So that was this directive, and it is 2004, which is kind of convenient because that is the time when all the most important treaties, which we know, Amsterdam, and we talk about it, and Nice, and then Lisbon, were brought. And now we talk about the insurance services. So this is kind of something that is related to this one, access to services. This is the test Ashar case. And can you see it? Or I will read it. I know that the online people can't see it perfectly, but can you see it? So here is actually, in practice, how discrimination works when it comes to access to certain services. And this case was, of course, the insurance, life insurance. I think it was life insurance, if I'm not correct. Yeah, they actually include always sex as a factor when calculating premiums. And there was like a difference always between men and women. And this was the court's reasoning. And since then, when you pay any kind of insurance, they ask you if you're a male or female, but they should use this unisex rule. Not only for the premiums, but also for the benefits. Yes.
But is there a different age for getting into pension system for men and women?
In the EU, yes, there is. You see that? Yes, it does. See, the last one, and good question, because the last paragraph deals with that. See, the court stressed that allowing open-ended use as sex as a risk factor meant that individuals could be treated differently throughout the union purely because of their sex. So what the court actually wanted to say, this last sentence, structural sex-based different, the way touch screen, which I don't know when it works. Sorry. That's about this we passed. Sex-based discrimination is a key economic sector. So what we have here, there is a difference for pension, but that is one part that is not regulated the same in each country. As you see, there won't be a directive dealing with pension system. Only with pension system. It can deal with social security, it can deal with insurance. Why? Because pension is not something that falls under the scope of competences of the European Union. But insurance is a service, especially private insurances. Not so much state insurances as private, especially when you pay your private life insurance or any other health insurance, etc. They need to be tackled in the same manner. But pension, no. This we will deal with in the following on Saturday, either online or in vivo, because this is very important for me because it covers the whole scope of Istanbul Convention, and it covers actually gender-based violence. And here it's always stated gender-based violence, so not violence towards women, but it's gender-based violence. And they do mention women, which are victims of gender-based violence, and children, which are usually because they're part of the family or household, but it's always discrimination based on gender. So this is kind of a new wave or a new kind of stream of directives which are now oriented towards gender-based discrimination, not discrimination based on sex. Mm-hmm. And we will deal with this in the following class. And this was kind of another case law, and this case law was also initiated by a man in Greece. And interestingly enough, this man wanted to take a paternity leave. He was a civil servant, so he worked for, I think, one of the ministries. I think it was Ministry of Foreign Affairs or something else. And he was a father. The fact was his wife was not employed. So the Greek law, when implementing directives, said, yes, you can take a parental leave, but only if your wife is employed or self-employed. And his wife was, I think she was doing something, but she was not registered as a self-employed or employed. So he challenged it and said that the EU legislation is not in accordance or compatible with gender equality directives. Because yes, you allow me paternity leave, but you only allow me if my wife works. If my wife doesn't work, then my rights are not really guaranteed in the Greek national system. And so it's important what the Court of Justice ruled. It says that, of course, Greek provisions are invalid and they're contrary to what was the aim of any kind of work and balance directive or parental leave directive, etc. Because in this case, they directly discriminate men because they said denying them parental leave based solely on sex, but also on what? On their wife employment status. So if the wife is employed, then the man gets the parental leave. If not, then the wife needs. And what they did is actually, and that was the whole discussion, is then the Greek legislation actually was still stuck in those prejudice that if women works, then the man should help her. But if women doesn't work, then she can handle the baby by herself. And then she can deal with the kids, etc., because he can go to work. And they were very much stuck in those traditional roles. And they said such rules perpetuate stereotypes where women are definitely primary caregivers and men are secondary. And then if women works, then okay, this secondary caregiver could be left with parental leave. And that is completely not in accordance with the directive's goals. So, and it actually was like a heating up all traditional roles which exist, especially they exist in, well, Greek is an Orthodox country, of course, as in ours, in Balkan country, but also they existed in those countries with strong Catholic basis, meaning Ireland, meaning, Poland, etc. So those two poles were the ones that were still having these traditional roles, as we still know with Poland, for example. And now we come to the work balance, the new one. It's 2019 in entry into force, and I think that the countries had until 2022 time to implement it, because you always leave sufficient enough of months, meaning minimum 24 months for a certain member state to implement. Member states somehow and somewhat can ask for a prolongation of that deadline, and they usually ask. And that is why we have this here. This is the transposition of this work balance directive. And the first more than 2 years, it was, as you can see, for paternity leave, it was intermediate. So not all countries actually implemented the rules on paternity leave, and especially on carers leave, which is very also relevant for us. As you remember that we have a law that's kako se zove ovaj zakon što je vezano. Da, roditelj njegovatelj. This was also the case in also a lot of countries with traditional roles where the carers leave was not at all tackled in national legislation, even though it was guaranteed in the directives. So it also, this is not like I'm kind of giving like it also happens in the EU, but it does happen also in the EU member states, where a parental leave somewhat was high in some countries where it was high before, and those were frugal states. Frugal states are full Scandinavian states, and those were where it was very high from the very beginning. They didn't even need those directives, but because in some, especially, okay, Norway is not in the EU, but the countries around Norway, so Scandinavia, it was the legislation is even better and even more balanced and even more gender oriented than it is in the European Union. And this is only for you to see. We don't need to go through it. What it does now, how it leads, like what it guarantees, what was before. So it introduced these 10 working days and introduced these kind of rights, which were days for carers leave, 4 months for parental leave, etc. So this is kind of very important because it covers like both parents, but we still have problem even in 2024. I have only the results from 2024. The results are kind of weak in the countries that were also challenged before, such as I said, traditional countries as Greece. Greece has a lot of cases even for the new this directive, and also in Poland and Hungary. And now we pass to the last one, which I'm going to cover today. This is the gender balance on corporate boards directive. Why do I cover that one? Because let me just see one thing. Yes, that was okay. Why? Because that was the one that was pending since 2012. So the first initiative to have this directive was introduced with the Commission in 2012, and it was more than 10 years in the Council discussing why should we even have a directive that wants to ensure that there is a quota, and we can say, or a positive action measure for women to be, in the listed companies with a certain percentage. And the third bullet point is the most important one. Third, if you can see it, if it's not scrambled. So the target. What is the target of that directive? That is to have at least 40% of underrepresented sex among non-executive directors and 33 among all directors. So both needs to be respected by the member states. And the deadline for transposition, meaning for harmonization of member states, is already passed, but the deadline for the companies is still not passed. So I cannot tell you what are the results right now. But what I can tell you is that this share right now, which I actually found for 2024, because for 2025 we still don't have it, is that the share of women is 34%, which looks nice. But that looks nice because some of the member states are actually implementing. Some of the member states even have quota. Norway, again, has quota from 2004. Yeah.
How can they impose quota?
Now you'll see how they will impose quotas.
How do they choose what
Who will be?
That's a great question. First question is yours because it's easier. Not small and medium enterprise. So not small, but large ones, which have their own stocks on public stock exchange, meaning only the biggest companies. So companies that have listed their stocks on the stock exchange, they must implement these positive action measures. Other countries, voluntary. Companies, voluntary. So it is voluntary, meaning it is desirable, but you don't have to do it. Again, in Norway and Sweden, I think it's kind of even more strict, and then they have your medium enterprises, which are also kind of mandatory. But on the level of the European Union, it's for the largest companies. And then again, see that in 2024, women accounted, the last one, 39.6 on the board members of the largest listed companies with binding gender quotas, compared to 33.8 in countries with soft measures. This is when we talk about what each country does without this directive. So if we did not have this directive, we would have a very, very nuanced approach, some countries would even reach, without the directive, would reach this threshold and say, yes, I have enough women in my corporate boards, in largest companies and in small and medium. But some countries are not even close enough. See, this 70% of countries have not taken no action at all. For example, in Latvia, there is not a single rule that deals with women, which should be present in the gender. The gender should be present in, and this gender representation in the corporate boards. What happened with Serbia is bivša povjerenica, so Brankica Janković, actually initiated also amendments. She was the one that proposed, but I don't think that something will happen right now. She proposed amendments to our own legislation on corporate companies in order for us also to introduce positive action measures for the largest companies in Serbia in order to have women present in the corporate boards dealing with this directive, because eventually we would have to harmonize with this directive eventually, because we had to harmonize as a country with every directive that is brought. So in order to prevent that, she proposed that amendment in order to have this gender parity even in the largest stock exchange companies. Nothing happened since that, because it was then 2024, but it was kind of a nice initiative which happened from the commissioner. Now your question, how are we going to ensure that companies first respect, and what do they need to respect, and what are the penalties, right, for the companies that do not respect those rules? This is where we come to a problem, because what happens, for example, if you have repeatedly only 3 men on kako se kaže konkurs, like on a call for a board. So it's not your, I would say, it's not your fault as a company. This is what I see as a gap right now. For example, for a huge listed company, you open a call, or you're going to elect somebody for a board member, and it needs to be voted. So what if the board members are the ones who vote? They elect men repeatedly, time after time. Yeah. So you need to also, they did not include that. They did not include that case at all. If the man is repeatedly, or men in general, are repeatedly elected by the other board members. So this is something that needs to be tackled from the very beginning. And since it's only past, I think, few months since the implementation, and the companies have from 2026 only to implement that, we will see how that will happen in practice. But what the question was, so you need to have transparent, of course, criteria. The criteria should be neutral, which is okay. And then you need to establish if there is an underrepresentation of a certain sex. If there is, then we have equally qualified candidates, and then we can give preference to, for example, women, because it's usually a woman. So what is also very, very important is that you always need to have a disclosure of everything that was done during the election process. Now we come to, what if the company does not do that? How do you report it? So what they propose here is to have a monitoring body. In every national legislation, or in every member state, they should have that already exists, but that will now also encompass one additional task, and that task would be monitoring if the largest companies have respected from 2026 onwards, when they have election procedures, if they respected this rule of gender neutral, transparent preference rule, etc. So firstly, monitoring. Secondly, what would be the penalties for companies? And this is still not in force. So they say here, penalties should be defined by member states. So this is also, as I see, a very vague part, where member states can choose their own penalties, which sometimes, because we're talking about very large companies, that penalty is not a scratch for that company. So that company thinks that the man is better to be in that board, and then they say, okay, we're going to pay some fine, and we're going to continue onwards. So this is also something because you leave and you need to leave because directive is something you give a goal, but you cannot really micromanage how to impose a penalty to a certain company by a certain member state. So how can you include fines? What they actually proposed is this: you annul the whole election process. So you say you contest this appointment and then you make them to do this whole appointment again. So annulment of the procedure. And then this is the last one, which is kind of a monitoring part. This directive requires member states to publish always gender balance targets in each large company. And then, as I said, the bodies for promotion and analysis, but we did that. And this is, as I said, to be achieved by 2026. So either we're going to know what happened. This is what I already told you. You need to have at least 40% or 33% of all director positions. What do you think? Oh, this was funny for me, but you can't see it. But you'll see it on the PowerPoint when I upload it.
You will laugh.
Yeah, you will. And at that point, you will laugh. What do you think are the big? Do you think that this is achievable in member states to have women CEOs of the large companies, to make them actually achieve that?
I'm not optimistic.
This is kind of a good. I'm not talking like a politician. Like, this is a good step forward. It is. You need to have something that kind of motivates and initiates this kind of politics. But if it's going to be dealt by member states in a proper manner, having in mind that those companies earn more than those states in most of the cases, I'm not sure. This penalty part, for me, is kind of the most worrying part of this whole procedure. So it's nice to have this as a condition. It's good. Even countries with their, they have sustainable goals. And one of the sustainable goals is, among them, is always gender parity, gender equality, etc. So they already deal with that because they have it. But in order to ensure that each stock exchange listed company would have 40% of non-executive members, that's very, very difficult to achieve. And we have 4 women here sitting very pessimistic regarding this directive. So not very good. But I mean, it's going to be difficult, but I think we're going to see the results, I think, in 2028. Because in 2026, companies are to respect this rule. Then they're going to ask for more time. Then they're going to establish the bodies who will monitor. Then we need to wait for the first monitoring report, for example, in countries which will be in the end of 2027. So in order to have the first, I would say, case law basis, we will wait another 4 years minimum to know if this is going to function. It's different with directive that we're going to work on in the next class, which is directive regarding gender-based violence, because that is something that is very tangible and that's very intertwined with the national criminal legal system, etc. And you can see if that is respected year per year. But this is something like a very on a carrot and a stick basis. So we're going to see it very long term. And okay, so I'm going to stop now because it's I know it's too much for the end of the class. And I'm somebody who said 8:25 was the guy who was very optimistic, but I did try to speak as fast as I can. And then what I'm going to do is I'm going to upload this Moodle to the Moodle account, and I'm going to also send you. I'm going to attach also this. I also want you to pay attention to gender equality strategy. I will have 5 minutes at the beginning of the next class regarding gender equality strategy. What I want to say for the end is that even though it is stated in the in our syllabus, whatever, where you see the headlines of each of the lecture that I'm going to talk about, I'm not going to deal a lot with external action and women in general, because that is something that really is not so relevant as the gender-based violence is. So I'm going to, as I'm Libra in horoscope, I'm going to give the balance, the prevalence to the gender-based violence when it comes to external action of the European Union and women, because when we talk about external action, it's like foreign affairs. And that the question is, do we have enough women in foreign diplomats and foreign diplomacy? Do we have enough women posts in defense of European Union? So I don't think it is important, but it is not equally important and something that we need to implement as well. And that is something where we deal on everyday basis, which is gender-based violence. So I'm going to put some materials on Moodle dealing with EU external action, but that was the topic proposed by my colleague Maja Lukic, who deals very much so with external action. I'm the one who deals with Istanbul Convention and EU directives, which are more light-like and everyday-like. So I'm going to give prevalence on the Saturday's lecture to those directives and the rules that were now implemented and provisions, implemented by the member states. Okay? Okay, by you. Okay. I'm going to stop sharing now. Is everything all right with the three of you that followed online? Are there?
Yes, everything is fine.
Okay. Okay. Hopefully it was kind of understandable and somewhat useful.
Professorka dar razumem.
Razumete? Okay. Super. Great. Great. Okay. So we're 15 minutes early because we had a shorter break, and I'll see you again on Saturday. Okay?
Okay, Professor. See you on Saturday. Thank you for the lecture.
Thank you for the
Thank you
lecture on
so
your
much,
time,
and thank
Professor.
you for following. Thank you. Excellent.